Hi, this is Ty Hyderall. I'm a plaintiff's lawyer. We concentrate in employment law and practice in New Jersey and New York. It's a very interesting case that came out of the Eastern District of New York, Palmer versus Amazon, which was a complaint filed in June of 2020 by a number of Amazon employees who work out of the fulfillment center that is, it's labeled JFK 8. It's in Staten Island. And it's a huge facility. It's 8 football fields, thousands of employees work there. And basically, Amazon had a policy called TOT, which stands for time off between events. And so Amazon would track how much time off employees took between them doing designated events at work or workplace type duties. And what Amazon employees contended was, wait a second, you're basically dinging us for taking time off to go to the bathroom and engage in acts which are recommended by the CDC, such as washing our hands for the requisite amount of time. You're dinging us for engaging in social distancing, whereby it takes more time to go from one place to another. And that's a violation of the New York labor laws as well as a public nuisance. And Amazon filed a motion to dismiss, and it was a very interesting motion. In the motion, Amazon basically said, listen, court, you're a tribunal. You are not well situated to make decisions such as decisions pertaining to safety in the workplace. OSHA is, not you. Second, the Amazon contended, well, to have a public nuisance, you have to contend some sort of special degree of injury and special kind. And they said, listen, COVID-19 affects everyone, and everyone is at risk for it, not just Amazon employees. So they don't meet the requirements to have a violation of the law to be able to move forward on a public nuisance type claim. Well, unfortunately for the Amazon employees, the Honorable Brian M. Cogan, who is the judge deciding the motion to dismiss, the judge agreed with Amazon and said, in this situation, the court is not well situated to make decisions about safety in the workplace. OSHA is, and this case really should have been filed with OSHA to make at least initial determinations. As to the public nuisance claim, the court also agreed that there was not any special kind of damages here that were unique to the Amazon employees, and thus unfortunately dismissed the case. So one thing to be wary of when you're filing claims or considering filing claims of safety in the workplace, certainly you may want to consider consulting with an attorney and discussing the various venues of where the claim should be filed, whether it should be filed simply in federal court or state court, or whether it should be filed first with OSHA, or whether it should be filed with both tribunals before making such important decisions, because of course the consequences can be significant at the end of the day. This is Ty Hyderall. Be safe and be well.